distribution exist. All rise. The Suffolk County Court of Common Pleas is now in session. The Honorable Allison McCarty presiding. Thank you. Be seated. All right. Good morning.
Good morning.
And we are here now today to hear the closing arguments in the case State of Ohio versus Kenan Ivery. The court is going to be reading those instructions to you. I am allowing you to follow along, so those notebooks that you have in front of you actually have the instructions right up there as you open them up. I'm going to ask you to not get ahead, just try to follow along, okay? And I will tell you that the court is required to give the instructions to you verbally. But sometimes I think it's helpful, and so in this situation, I'm going to allow you to have them in writing ahead of time and follow along. Those notebooks contain other information in them as well that you can review when you are in your deliberations. They contain a list of the witnesses that testified in this trial, a list of the exhibits that were proffered by both parties, and also they will contain the verdict forms. We'll give you a supplemental packet with those in them shortly, after we take a break. So I'm going to ask you to write your juror number in the upper right-hand corner of the first page there where it says closing jury instructions, because that's the only way that you're going to be able to keep track that that is your copy. And you are free to make notes in those as you wish while I'm reading the instructions and or during deliberations or closings. Okay, at any time you can make notes in those. Ladies and gentlemen of the jury, you have heard, oh, you know what, there is something we need to do for the record, correct? Mr. Baumel? On this, yeah, over here. Ladies and gentlemen, you have now heard all of the evidence. You're about to hear the arguments of counsel, and it's now my duty to instruct you as to the law that applies in this case. Now, the court and the jury have separate functions. You decide the disputed questions of fact, and the court provides you with these instructions of law. It is your sworn duty to accept these instructions and to apply the law to the facts as you determine those facts to be. You are not permitted to change the law nor to apply your own ideas as to what you think the law should be. Now, a criminal case begins with the filing of an indictment accusing or charging the defendant of committing particular crimes. The indictment in this particular case is for aggravated murder, attempted murder, felonious assault, having weapons while on a disability, carrying concealed weapons, illegal possession of a firearm in a liquor permit premises, and tampering with evidence. Several counts have specifications for you to decide also. It is important that you understand that the filing of the indictment, or the indictment itself, is in no way to be considered by you as evidence against the defendant. The filing of the indictment informs the defendant that he has been accused of the offenses. The plea of not guilty is a denial by the defendant of the crimes that are charged and puts into issue all of the essential elements of the crimes charged. Now, the defendant is presumed to be innocent unless and until his guilt is established beyond a reasonable doubt. The defendant must be acquitted unless the state produces evidence which convinces you beyond a reasonable doubt of each and every element of the crimes alleged. I am now going to define reasonable doubt for you. Reasonable doubt is present when you, the jurors, after you have carefully considered and compared all of the evidence, cannot say you are firmly convinced of the truth of the charge. It is a doubt based on reason and common sense. Reasonable doubt is not mere possible doubt, because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of his or her own affairs. Now I'll define evidence for you. Evidence is the testimony from the witnesses, the exhibits admitted during the trial, and any stipulations agreed to by counsel. Evidence may be direct, or it may be circumstantial, or a combination of the two. Direct evidence and circumstantial evidence are of equal weight or probative value. Direct evidence is testimony given by a witness who has seen or heard or felt certain acts or facts to which he or she testifies. Direct evidence includes exhibits admitted during the trial. Evidence may also be used to prove a fact by an inference. This type of evidence is called circumstantial evidence. It is the proof of facts by direct evidence from which you may infer other reasonable related facts or conclusions which naturally and logically follow according to the common experience of mankind. And just to give you an example, say as you looked out your window last night, you saw that the ground was dry and clear. It certainly was a beautiful day yesterday in northeastern Ohio, I have to say. The ground was dry and clear. You went to bed, you didn't see anything, you didn't hear anything, and you woke up in the morning, and when you opened the door, the ground was covered in a blanket of white snow. There was snow on the bushes, snow on the ground, snow covering your newspaper, snow in the trees, and snow on your driveway. And even though during the course of the evening you didn't actually witness snow falling directly, you can infer from not having snow on the ground the night before to having snow on the ground the next morning that during the course of the evening, snow fell. To infer or to make an inference is to reach a reasonable conclusion of fact, which you may, but are not required to make, from other facts which you find have been established by direct evidence. Whether an inference is made rests entirely with you. The evidence, as I have said, does not include the indictment. It does not include the answers to questions you were instructed to disregard, or the opening or closing statements of counsel. The opening statements and closing arguments of counsel are designed to assist you, but they are not evidence. Now, you must not speculate as to the reason why the court sustained an objection to any question, or to what the answer to that question might have been. You must not draw any inference or speculate on the truth of any suggestion included in a question that was not answered. You, the jury, participated in a jury view of the premises known as Papa Don's Pub, and you were also able to view a location off of the highway where the defendant was arrested. As previously instructed, your view of these locations is not evidence, but it is offered as assistance to help you to understand the evidence presented in the courtroom. You, the jury, are the sole judges of the facts, the credibility or believability of the witnesses, and the weight of the evidence. To weigh the evidence, you must consider the credibility of each person who testified. You must apply the tests for truthfulness that you apply in your daily lives. These tests include the appearance of the witness on the stand, his or her manner of testifying, the reasonableness of the testimony, the opportunity he or she had to see, hear, or feel the things about which he or she testified, the accuracy of the witness's memory, the witness's frankness or lack of it, the witness's intelligence, bias, interest in the outcome, if any, the witness's prior criminal record, if any, together with all the facts and circumstances surrounding the testimony. Applying these tests, you will determine the weight to be given to each witness's testimony. Remember, you may believe or disbelieve all or any part of the testimony of any witness. It is your province to determine what testimony is worthy of belief and what testimony is not worthy of belief. You should not decide any issue of fact merely on the basis of the number of witnesses who testify to each side of an issue. Rather, the final test in judging evidence would be the force and weight of the evidence, regardless of the number of witnesses on each side of an issue. The testimony of one witness, believed by you, is sufficient to prove any fact. Also, discrepancies in a witness's testimony, or between his or her testimony and that of others, if there are any, does not necessarily mean that you should disbelieve the witness, as people commonly forget facts or recollect them erroneously after the passage of time. You are certainly all aware of the fact that two persons who are witnesses to an incident may often see or hear it differently. In considering a discrepancy in a witness's testimony, you should consider whether such discrepancy concerns an important fact or a trivial one. If you conclude that a witness has willfully lied in his or her testimony as to a material fact, you may distrust all of his or her testimony, and you would then have the right to reject all of his or her testimony, unless, from all of the evidence, you believe that the probability of truth favors his or her testimony in other particulars. The testimony of the defendant is to be weighed by the same rules that apply to every other witness. Now, normally, in a courtroom, a witness may not express an opinion. However, one who follows a profession or special line of work may express his or her opinion because of his or her education, knowledge, and experience. We have had numerous experts testify in this case. Ms. Farinacci, Ms. Violi, Mr. Gardner from BCI, and Dr. Dean from the Medical Examiner's Office. Such testimony is admitted for whatever assistance it may provide to help you arrive at a just verdict. Questions have been asked in which expert witnesses were permitted to assume that certain facts were true and to give an opinion based upon such assumption. You must determine whether the assumed facts upon which the experts based their opinion are true. If any assumed fact was not established, you will determine its effect upon the opinion of the experts. However, as with other witnesses, upon you alone rests the duty of deciding what weight should be given to the testimony of the experts. In determining its weight, you may take into consideration their skill, experience, knowledge, veracity or truthfulness, familiarity with the facts of this case, and the usual rules for testing credibility and determining the weight to be given to testimony. Evidence was received that the defendant has previously been convicted of possession of cocaine, trafficking in cocaine, illegal assembly or possession of chemicals for the manufacture of drugs, and having a weapon while under a disability. That evidence was received for two limited purposes. It was not received, and you may not consider it, to prove the character of the defendant in order to show that he acted in conformity with that character. If you find that the defendant was convicted of those offenses, you may consider that evidence only for the following purposes. 1, to test the defendant's credibility or believability and the weight to be given to the defendant's testimony, and 2, to decide whether it proves an element of one of the offenses charged, specifically the weapon under disability charge. That evidence cannot be used for any other purpose. To decide what the defendant's motivation was, then you should not consider this evidence for any purpose. However, if you find that the facts support that the defendant engaged in such conduct, and if you decide that the defendant was motivated by a consciousness or an awareness of guilt, you may, but are not required to, consider that evidence in deciding whether the defendant is guilty of any of the crimes charged. You alone will determine what weight, if any, to give to this evidence. I will now discuss the specific charges with you. In count 1, the first count of the indictment, the defendant is charged with aggravated murder. Before you can find the defendant guilty, you must find, beyond a reasonable doubt, that on or about the 16th day of November in the year 2014 and in Summit County, Ohio, the defendant Kenan Ivery purposely and with prior calculation and design caused the death of Justin Winebrenner. Purpose is an essential element of the offense of aggravated murder. A person acts purposely when it is his specific intention to cause a certain result. It must be established in this case that at the time in question, there was present in the mind of the defendant a specific intention to cause the death of Justin Winebrenner. Purpose is the decision of the mind to do an act with the conscious objective of producing a specific result. To do an act purposely is to do it intentionally and not accidentally. Purpose and intent mean the same thing. The purpose with which a person does an act is known only to himself, unless he expresses it to others or indicates it by his conduct. The purpose with which a person does an act is determined from the manner in which it is done, the means or weapon used, and all other facts and circumstances in evidence. You will determine from those facts and circumstances whether there existed at the time in the mind of the defendant a specific intention to cause the death of Justin Winebrenner. If a wound is inflicted upon a person with a deadly weapon in a manner calculated to destroy life, the purpose to cause the death may be, but is not required to be, inferred from the use of the weapon. The inference, if made, is not conclusive. Proof of motive is not required. The presence or absence of motive is one of the circumstances bearing upon purpose. Must show a scheme designed to carry out the calculated decision to cause the death. No definite period of time must elapse, and no particular amount of consideration must be given. But acting on the spur of the moment or after momentary consideration of the purpose to cause the death is not sufficient. Cause is an essential element of the offense of aggravated murder. Cause is an act which directly produces the death of another, and without which it would not have occurred. The defendant's responsibility is not limited to the immediate or most obvious result of the defendant's act or failure to act. The defendant is also responsible for the natural and foreseeable consequences or results that follow in the ordinary course of events from the act or failure to act. If you find that the state proved beyond a reasonable doubt each and every essential element of this offense of aggravated murder, then your verdict must be guilty according to your findings. If you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of aggravated murder, then your verdict must be not guilty according to your findings. If you find the defendant guilty of this or any of the other offenses in counts 1 through 11 in the indictment, it is your duty to deliberate further and to decide the specifications attached to those counts. A specification is an additional finding made by the grand jury arising out of the facts of the offenses charged in the indictment. If you find the defendant not guilty of any offense or offenses, you will not consider the specification or specifications related to that offense. Specification 1 to count 1 is the course of conduct specification. If your verdict is guilty, you will separately decide beyond a reasonable doubt whether the aggravated murder was part of a course of conduct involving the purposeful killing of or attempt to kill 2 or more persons by Kenan D. Ivery. If your verdict is not guilty, you will not decide this issue. Purpose has already been defined for you. Course of conduct means that there is some factual link between the aggravated murder with which the defendant is charged and the other purposeful attempted killings of another person or other people that are alleged to make up the course of conduct. The factual link can be one of time, location, weapon used, cause of death or injury, or similar motivation on the defendant's part for his crimes. All of the circumstances of the offenses must be taken into account, and there must be some connection, common scheme, plan, pattern, or psychological thread that ties the offenses together. Specification 2 to count 1 is what we call firearm specification. If your verdict is guilty, you will separately decide beyond a reasonable doubt whether the defendant discharged a firearm at a peace officer while committing the offense. If your verdict is not guilty, you will not consider this specification. Actually, we call that the peace officer specification, but they had it listed. We have it listed as a firearm specification. It's kind of both. Firearm means any deadly weapon capable of expelling or propelling one or more projectiles by the action of an explosive or combustible propellant. Firearm includes an unloaded firearm and any firearm which is inoperable but which can be readily rendered operable. When deciding whether a firearm is capable of expelling or propelling one or more projectiles by the action of an explosive or combustible propellant, you may rely on circumstantial evidence, including, but not limited to, the statements or representations and actions of the individual exercising control over the firearm. Firearm, I say up here, firearm means any deadly weapon, so now I'm going to define deadly weapon. Deadly weapon means any instrument, device, or thing capable of inflicting death and designed or specially adapted for use as a weapon or possessed, carried, or used as a weapon. Peace officer includes, but is not limited to, a sheriff, deputy sheriff, marshal, deputy marshal, or a member of the organized police department of any municipal corporation. Specification 3 to count 1 is a firearm specification. If your verdict is guilty, that means as to the original offense, count 1, you will separately decide beyond a reasonable doubt if the defendant had a firearm on or about his person or under his control while committing the offense and either displayed, brandished, indicated that he possessed the firearm, or used it to facilitate the commission of the offense. If your verdict is not guilty, you will not decide this issue. On or about his person or under his control means that the firearm was either carried on the defendant's person or was so near the defendant's person as to be conveniently accessible and within his immediate physical reach. Brandish means to wave or exhibit in a menacing or challenging way. Firearm, capable of expelling or propelling, and deadly weapon have been defined for you in specification 2. Now in count 2, the defendant is charged with murder. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 16th day of November in the year 2014 and in Summit County, Ohio, the defendant did purposely cause the death of Justin Winebrenner. Purposely and causation were already defined for you in count 1. If you find that the state proved beyond a reasonable doubt each and every essential element of the offense of murder, your verdict must be guilty according to your findings. If you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of murder, then your verdict must be not guilty according to your findings. Specification 1 to count 2 is a firearm specification relating to a peace officer. If your verdict is guilty, you will separately decide beyond a reasonable doubt whether the defendant discharged a firearm at a peace officer while committing the offense. If your verdict is not guilty, you will not consider this specification. You will use the same definitions listed in the firearm specifications to count 1. Specification 2 to count 2 is another firearm specification. If your verdict is guilty, you will separately decide beyond a reasonable doubt if the defendant had a firearm on or about his person or under his control while committing the offense and either displayed, brandished, indicated that he possessed the firearm, or used it to facilitate the commission of the offense. If your verdict is not guilty, you will not decide this issue. You will use the same definitions listed in the firearm specifications to count 1. In count 3, the defendant is charged with murder. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 16th day of November in the year 2014 and in Summit County, Ohio, the defendant, Kenan Ivery, did cause the death of Justin Winebrenner as a proximate result of committing or attempting to commit an offense of violence that is a felony of the first or second degree, to wit, felonious assault. Causation was already defined for you in count 1. While committing means that the death must occur as part of acts leading up to or occurring during or immediately after the commission of felonious assault, and that the death was directly associated with the commission of a felonious assault. Attempt means purposely or knowingly engaging in conduct which, if successful, would have constituted or resulted in the commission of felonious assault. The underlying charge of felonious assault is defined for you in count 4. So in the next count, I'll define what felonious assault is. I instruct you as a matter of law that felonious assault is an offense of violence and is, depending on whether the victim is a peace officer or not, either a felony of the first or second degree in the state of Ohio. If you find that the state proved beyond a reasonable doubt each and every essential element of the offense of murder, your verdict must be guilty according to your findings. If you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of murder, then your verdict must be not guilty according to your findings. In count 3, there's specification 1 to count 3. If your verdict is guilty, you will separately decide beyond a reasonable doubt whether the defendant discharged a firearm at a peace officer while committing the offense. If your verdict is not guilty, you will not consider the specification, and you will use the same definitions listed in the firearm specifications to count 1. As to specification 2 to count 3, if your verdict is guilty, you will separately decide beyond a reasonable doubt if the defendant had a firearm on or about his person or under his control and while committing the offense, and either displayed, brandished, indicated that he possessed the firearm, or used it to facilitate the commission of the offense. If your verdict is not guilty, you will not decide this issue. You will use the same definitions listed in the firearm specifications to count 1. In count 4, the defendant is charged with felonious assault. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 16th day of November 2014, and in Summit County, Ohio, the defendant did knowingly cause or attempt to cause physical harm by means of a deadly weapon to Justin Winebrenner, a peace officer. Peace officer has previously been defined for you. A person acts knowingly, regardless of his purpose, when he is aware that his conduct will probably cause a certain result, or he is aware that his conduct will probably be of a certain nature. A person has knowledge of circumstances when he is aware that such circumstances probably exist. Knowingly means that a person is aware of the existence of the facts and that his acts will probably cause a certain result or be of a certain nature. Since you cannot look into the mind of another, knowledge is determined from all the facts and circumstances in evidence. You will determine from these facts and circumstances whether there existed at the time in the mind of the defendant an awareness of the probability that he was causing or attempting to cause physical harm to Justin Winebrenner by means of a deadly weapon. Proof of motive is not required. The presence or absence of motive is one of the circumstances bearing upon purpose or knowledge. Where an act is a crime, a good motive or purpose is not a defense. Now, the state charges that the act or failure to act of the defendant caused physical harm to a person. Cause is an essential element of this offense. Cause is an act or failure to act which in a natural and continuous sequence directly produces the physical harm to a person and without which it would not have occurred. Physical harm to persons means any injury, illness, or other physiological impairment, regardless of its gravity or duration. The defendant's responsibility is not limited to the immediate or most obvious result of the defendant's act or failure to act. The defendant is also responsible for the natural and foreseeable consequences or results that follow in the ordinary course of events from the act or failure to act. An attempt occurs when a person knowingly engages in conduct that, if successful, would result in physical harm. If you find that the state proved beyond a reasonable doubt each and every essential element of the offense of felonious assault, your verdict must be guilty according to your findings. If you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of felonious assault, then your verdict must be not guilty according to your findings. If your verdict is guilty, you will separately decide beyond a reasonable doubt whether the victim, Justin Winebrenner, was a peace officer. If your verdict is not guilty, you will not consider this additional finding. Peace officer has previously been defined for you. Specification 1 to count 4, if your verdict is guilty, you will separately decide beyond a reasonable doubt whether the defendant discharged a firearm at a peace officer while committing the offense. If your verdict is not guilty, you will not consider this specification. You will use the same definitions listed in the firearm specifications to count 1. If your verdict is guilty, you will separately decide another specification, and that is beyond a reasonable doubt if the defendant had a firearm on or about his person or under his control while committing the offense, and either displayed, brandished, indicated that he possessed the firearm, or used it to facilitate the commission of the offense. If your verdict is not guilty, you will not decide this issue. You will use the same definitions listed in the firearm specifications to count 1. Now in count 5, the defendant is charged with attempted murder. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 16th day of November in the year 2014, and in Summit County, Ohio, the defendant, Kenan Ivery, did purposely engage in conduct that, if successful, would constitute or result in the offense of murder, to wit, he did purposely attempt to cause the death of David Wokady. Murder is defined as purposely causing the death of another. The definitions of the elements purposely and causation have previously been defined for you. This concludes the definitions for murder. I will continue with remaining definitions for attempted murder. The defendant is charged with purposely attempting to cause the death of David Wokady. A criminal attempt is when one purposely does or fails to do anything which is an act or omission constituting a substantial step in a course of conduct planned to culminate in his commission of the crime. To constitute a substantial step, the conduct must be strongly corroborative of the actor's criminal purpose. As to this charge, an attempt occurs when a person purposely engages in conduct that, if successful, would constitute or result in the offense of murder. Preparation. Preparing, planning, or arranging the means for the commission of the crime does not constitute an attempt. It is not a defense to a charge of attempt that, in retrospect, the commission of the offense, which was the object of the attempt, was impossible under the circumstances. If you find that the state proved beyond a reasonable doubt each and every essential element of the offense of attempted murder, your verdict must be guilty according to your findings. If you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of attempted murder, then your verdict must be not guilty according to your findings. Specification 1 to count 5. If your verdict is guilty, you will separately decide beyond a reasonable doubt if the defendant had a firearm on or about his person or under his control while committing the offense, and either displayed, brandished, indicated that he possessed a firearm, or used it to facilitate the commission of the offense. If your verdict is not guilty, you will not decide this issue. You will use the same definitions listed in the firearm specifications to count 1. I see I've got a typo there. Should say 6th count. In the 6th count of the indictment, the defendant is charged with attempted murder. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 16th day of November 2014 and in Summit County, Ohio, the defendant did purposely engage in conduct that, if successful, would constitute or result in the offense of murder. To wit, he did purposely attempt to cause the death of David Isel. You will use the definitions previously given to you in count 5. If you find that the state proved beyond a reasonable doubt each and every essential element of the offense of attempted murder, your verdict must be guilty according to your findings. If you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of attempted murder, then your verdict must be not guilty according to your findings. Specification attached to count 6. If your verdict is guilty, you will separately decide beyond a reasonable doubt whether the defendant discharged a firearm. That's not right. That should be taken out. So, there's only one specification as to count 6, and it's actually specification 2, so it should, and it is correct on the verdict form. So I'm going to instruct you to cross off what's listed as specification 1, and I'm going to read you specification 2, but I'm telling you it's the only specification as to count 6. So if your verdict is guilty, you will separately decide beyond a reasonable doubt if the defendant had a firearm on or about his person or under his control while committing the offense, and either displayed, brandished, indicated that he possessed the firearm, or used it to facilitate the commission of the offense. If your verdict is not guilty, you will not decide this issue. You will use the same definitions listed in the firearm specifications to count 1. In count 7, the defendant is charged with felonious assault. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 16th day of November in the year 2014 and in Summit County, Ohio, the defendant did knowingly cause or attempt to cause physical harm to David Wolfgang, and that should add there, by means of a deadly weapon. You are to use the definitions previously given to you in count 5. You will find that the state proved beyond a reasonable doubt each and every essential element of the offense of felonious assault. Your verdict must be guilty according to your findings. If you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of felonious assault, then your verdict must be not guilty according to your findings. As to specification 1, if your verdict is guilty, you will separately decide beyond a reasonable doubt if the defendant had a firearm on or about his person or under his control while committing the offense, and either displayed, brandished, indicated that he possessed the firearm, or used it to facilitate the commission of the offense. If your verdict is not guilty, you will not decide this issue. You will use the same definitions listed in the firearm specification to count 1. In count 11, the defendant is charged with felonious assault. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 16th day of November in the year 2014 and in Summit County, Ohio, the defendant did knowingly cause or attempt to cause physical harm to Jennifer Imhoff by means of a deadly weapon. And so you need to write that in there so you make sure you have that on this felonious assault counts. Got left off. You are to use the definitions previously given to you in count 5. Now, if you find, as to this count, count 8, felonious assault allegation regarding Jennifer Imhoff, if you find that the defendant was attempting to cause injury to Dave Wolcady, David Eisel, or Justin Winebrenner, and that his act or acts unintentionally or accidentally caused injury to Jennifer Imhoff, then the defendant is as responsible as if his act or acts had harmed Dave Wolcady, David Eisel, and or Justin Winebrenner. If you find that the state proved beyond a reasonable doubt each and every essential element of the offense of felonious assault, your verdict must be guilty according to your findings. If you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of felonious assault, then your verdict must be not guilty according to your findings. Specification 1, if your verdict is guilty, you will separately decide beyond a reasonable doubt if the defendant had a firearm on or about his person or under his control while committing the offense, and either displayed, brandished, indicated that he possessed the firearm, or used it to facilitate the commission of the offense. If your verdict is not guilty, you will not decide this issue. You will use the same definitions listed in the firearm specifications to count 1. In count 9, the defendant is charged with felonious assault. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 16th day of November in the year 2014 and in Summit County, Ohio, the defendant did knowingly cause or attempt to cause physical harm to Michael Capes, add in there, comma, by means of a deadly weapon. You are to use the definitions previously given to you in count 5. If you find that the defendant was attempting to cause injury to Dave Wolcady, David Eisel, or Justin Winebrenner, and that his act or acts unintentionally or accidentally caused injury to Michael Capes, then the defendant is as responsible as if his act or acts had harmed David Wolcady, David Eisel, and or Justin Winebrenner. If you find that the state proved beyond a reasonable doubt each and every essential element of the offense of felonious assault, your verdict must be guilty according to your findings. If you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of felonious assault, then your verdict must be not guilty according to your findings. Specification to count 9, if your verdict is guilty, you will separately decide beyond a reasonable doubt if the defendant had a firearm on or about his person or under his control while committing the offense, and either displayed, brandished, indicated that he possessed the firearm, or used it to facilitate the commission of the offense. If your verdict is not guilty, you will not decide this issue. We use the same definitions listed in the firearm specifications to count 1. In count 10, the defendant is charged with felonious assault. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 16th day of November in the year 2014 and in Summit County, Ohio, the defendant did knowingly cause or attempt to cause physical harm to Thomas Russell by means of a deadly weapon. Add that in there. Can I see the parties at timer real quick here? Okay, I'm going to reread count 10 to you. I just wanted to clarify something. In count 10, the defendant is charged with felonious assault. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 16th day of November in the year 2014 and in Summit County, Ohio, the defendant did knowingly cause or attempt to cause physical harm to Thomas Russell, comma, a peace officer, comma, by means of a deadly weapon. All right? And then I'm going to tell you that you are to use the definitions previously given to you, and I'm going to look back, and I think it's in count 4. Definitions in count 4. Okay. If you find that the defendant was attempting to cause physical harm by means of a deadly weapon to David Mulcahy, David Eisel, or Justin Winebrenner, and that his act or acts unintentionally or accidentally caused injury to Thomas Russell, then the defendant is as responsible as if his act or acts had caused physical harm by means of a deadly weapon to David Mulcahy, David Eisel, and or Justin Winebrenner. If you find that the state failed to prove beyond a reasonable doubt, if you find that the state proved beyond a reasonable doubt each and every essential element of the offense of felonious assault, your verdict must be guilty according to your findings. If you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of felonious assault, then your verdict must be not guilty according to your findings. If your verdict is guilty, you will separately decide the specification, and that's specification 1, and that's beyond a reasonable doubt whether the defendant discharged a firearm at a peace officer while committing this offense. If your verdict is not guilty, you will not consider the specification. You will use the same definitions listed in the firearm specifications to count 1. If your verdict is guilty as to the original charge, you will also consider specification 2. You will separately decide beyond a reasonable doubt if the defendant had a firearm on or about his person or under his control while committing the offense and either displayed, brandished, indicated that he possessed the firearm, or used it to facilitate the commission of the offense. If your verdict is not guilty, you will not decide this issue, and you will use all the same definitions listed in the firearm specifications to count 1. In count 11, the defendant is charged with felonious assault. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 16th day of November in the year 2014 and in Summit County, Ohio, the defendant did knowingly cause or attempt to cause physical harm to David Eisel, comma, by means of a deadly weapon. You are to use the definitions previously given to you in count 5. Actually, it's count 4, not 5. Count 4 is the previous felonious assault count. If you find that the state proved beyond a reasonable doubt each and every essential element of the offense of felonious assault, your verdict must be guilty according to your findings. If you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of felonious assault, then your verdict must be not guilty according to your findings. There's a specification to count 11. If your verdict is guilty, you will separately decide beyond a reasonable doubt if the defendant had a firearm on or about his person or under his control while committing the offense, and either displayed, brandished, indicated that he possessed the firearm, or used it to facilitate the commission of the offense. If your verdict is not guilty, you will not decide this issue. You use the same definitions listed in the firearm specifications to count 1. In count 12, the defendant is charged with having the weapon while under disability. Before the defendant can be found guilty of this offense, the state of Ohio must prove beyond a reasonable doubt that on or about the 16th day of November in the year 2014, and in Summit County, Ohio, the defendant, Kenan Ivery, without being relieved from disability, did knowingly acquire, have, carry, or use any firearm or dangerous ordinance, and was convicted of a felony offense involving the illegal possession, use, sale, administration, distribution, or trafficking in any drug of abuse. Knowingly, firearm, and deadly weapon have previously been defined for you. Possess means having control over a thing or substance, but may not be inferred solely from mere access to the thing or substance through ownership or occupation of the premises upon which the thing or substance is found. Although mere presence of a person in the vicinity of contraband is not enough to support possession, evidence that an individual was within close proximity to readily use a substance may support a conclusion that the individual had constructive possession. Constructive possession exists when an individual knowingly exercises dominion and control over an object, even though that object may not be within the individual's immediate physical possession. It is not necessary to establish ownership of a controlled substance in order to establish even constructive possession. Joint possession exists when two or more persons together have the ability to control an object, exclusive of others. The word had means possessed. Drug of abuse means any controlled substance, harmful intoxicant, or dangerous drug as defined by law. I instruct you as a matter of law that in the state of Ohio, cocaine is a Schedule II controlled substance and is a drug of abuse. If you find that the state proved beyond a reasonable doubt each and every essential element of the offense of having a weapon while under disability, your verdict must be guilty according to your findings. If you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of having weapons while under disability, then your verdict must be not guilty according to your findings. In count 13, the defendant is charged with carrying concealed weapons. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 16th day of November in the year 2014 and in Summit County, Ohio, the defendant, Kenan Ivery, knowingly carried or had a deadly weapon concealed on his person or ready at hand, to wit, a handgun, and said deadly weapon was a firearm which was loaded or for which ammunition was ready at hand. Knowingly, had, possessed, deadly weapon, and firearm have previously been defined for you. Concealed means that the deadly weapon was out of sight or so hidden that it could not be seen by ordinary observation by others near enough to see it. Ready at hand means so near as to be conveniently accessible and within immediate physical reach. If you find that the state proved beyond a reasonable doubt each and every essential element of the offense of carrying concealed weapons, your verdict must be guilty according to your findings. If you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of carrying concealed weapons, then your verdict must be not guilty according to your findings. Count 14 is illegal possession of a firearm in a liquor permit premises. In count 14, the defendant is charged with illegal possession of a firearm in a liquor permit premises. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 16th day of November 2014 and in Summit County, Ohio, the defendant possessed a firearm in any room in which any person is consuming beer or intoxicating liquor in a premises for which a D permit has been issued under Revised Code Chapter 4303, and did knowingly carry or had the firearm concealed on the offender's person or concealed ready at hand. Possession and firearm have previously been defined for you. If you find that the state proved beyond a reasonable doubt each and every essential element of the offense of illegal possession of a firearm in liquor permit premises, your verdict must be guilty according to your findings. If you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of illegal possession of a firearm in a liquor permit premises, then your verdict must be not guilty according to your findings. In count 15, which is the final count, the defendant is charged with tampering with evidence. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 16th day of November 2014 and in Summit County, Ohio, the defendant, knowing that an official proceeding or investigation was in progress or about to be instituted or likely to be instituted, altered, destroyed, concealed, or removed a record, document, or thing, to wit, gun magazine, with purpose to impair its value or availability as evidence in such proceeding or investigation. Purposely and knowingly were previously defined for you. An official proceeding means any proceeding before a legislative, judicial, administrative, or other governmental agency or official authorized to take evidence under oath, and includes any proceeding before a referee, hearing examiner, commissioner, notary, or other person taking testimony, or a deposition in connection with an official proceeding. A public official means any elected or appointed officer or employee or agent of the state or any political subdivision thereof, whether in a temporary or permanent capacity, and includes without limitation legislators, judges, and law enforcement officers. If you find that the state proved beyond a reasonable doubt each and every essential element of the offense of tampering with evidence, your verdict must be guilty according to your findings. If you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of tampering with evidence, then your verdict must be not guilty according to your findings. The defendant is asserting an affirmative defense, known as self-defense, as to the charges in counts 1 through 11. The burden of going forward with the evidence of self-defense and the burden of proving self-defense are upon the defendant. He must establish such a defense by a preponderance of the evidence. Preponderance of the evidence is the greater weight of the evidence. That is, evidence that you believe because it outweighs or overbalances in your minds the evidence opposed to it. A preponderance means evidence that is more probable, more persuasive, or of greater probative value. It is the quality of the evidence that must be weighed. Quality may or may not be identical with quantity or the number of witnesses. In determining whether or not an affirmative defense has been proved by preponderance of the evidence, you should consider all of the evidence bearing upon that issue, regardless of who produced it. If the weight of the evidence is equally balanced, or if you are unable to determine which side of an issue has the preponderance, then the defendant has not established the affirmative defense of self-defense. If the defendant fails to establish the defense of self-defense, the state of Ohio still must prove to you beyond a reasonable doubt each and every element of the crime or crimes charged. To establish self-defense, the defendant must prove that A, he was not at fault in creating the situation giving rise to the use of deadly force, and B, he had reasonable grounds to believe and an honest belief that he was in imminent or immediate danger of death or great bodily harm, and that his only means of retreat, escape, or withdrawal from such danger was by the use of deadly force, and C, he had not violated any duty to retreat, escape, or withdraw to avoid the danger. The defendant had a duty to retreat if A, the defendant was at fault in creating the situation giving rise to the use of deadly force, or B, the defendant did not have reasonable grounds to believe and an honest belief that he was in imminent or immediate danger of death or great bodily harm, and that his only means of escape from that danger was by the use of deadly force. The defendant no longer had a duty to retreat if A, he retreated, escaped, or withdrew from the situation or reasonably indicated his intention to retreat, escape, or withdraw from the situation and no longer participate in it, and he then had reasonable grounds to believe and an honest belief that he was in imminent or immediate danger of death or great bodily harm, and the only reasonable means of escape from that danger was by the use of deadly force, even though he was mistaken as to the existence of that danger. Reasonableness. Words alone do not justify the use of deadly force. Resort to such force is not justified by abusive language, verbal threats, or other words, no matter how provocative. In deciding whether the defendant had reasonable grounds to believe and an honest belief that he was in imminent or immediate danger of death or great bodily harm, you must put yourself in the position of the defendant. with his characteristics and his knowledge or lack of knowledge, and under the circumstances and conditions that surrounded him at the time. You must consider the conduct of the other patrons of the bar and decide if their acts and words caused the defendant reasonably and honestly to believe that he was about to be killed or receive great bodily harm. The law does not measure nicely the degree of force which may be used to repel an attack. However, if the defendant used more force than reasonably appears to be necessary under the circumstances, and if the force used is so greatly disproportionate to his apparent danger as to show an unreasonable purpose to injure the patrons of the bar, then the defense of self-defense is not available. If the defendant fails to establish the defense of self-defense, the state still must prove to you beyond a reasonable doubt each and every essential element of the crime or crimes charged. If you find that the state proved beyond a reasonable doubt each and every essential element of the offenses in counts 1 through 11, and that the defendant failed to prove by a preponderance of the evidence the defense of self-defense, then you must find the defendant guilty of those respective offenses. If you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of any of the offenses in counts 1 through 11, or if you find that the defendant proved by a preponderance of the evidence the defense of self-defense, then you must find the defendant not guilty as to those respective offenses. If you find that the state proved beyond a reasonable doubt each and every essential element of any one or more of the offenses charged in the separate counts in the indictment, your verdict must be guilty as to such offense or offenses according to your findings. If you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of any one or more of the offenses charged in the separate counts in the indictment, your verdict must be not guilty as to such offense or offenses according to your findings. The charges set forth in each count in the indictment constitute a separate and distinct matter. You must consider each count and the evidence applicable to each count separately, and you must state your finding as to each count uninfluenced by your verdict as to any other count. The defendant may be found guilty or not guilty of any one or all of the offenses charged. That concludes my preliminary instructions. I'm going to now allow you to take a break because it's the court's wish that if possible we can go through the arguments without any break. So we're going to give you a 15-minute break now and have Shay take you back to the jury room, but from there you can go ahead and take the break. Okay? Remember all the admonitions about discussing, investigating, deciding, everybody related to this case. All rise. Just leave everything on the chair. Oh, you're saying in count 8 it says?
Yeah, look at page 26.
Yeah. Okay.
Just look up pictures.
Yeah, you can come out.
Did she? I can switch them out right now just to be safe.
All right, so the only thing on the verdict forms was add that additional fine against him as count 10.
Russell's felonious.
Right, all right.
Just would reflect the same one that Brendan, like Brendan's felonious.
All right, which means that the list of charges